Rule 118 Pretrial. Pretrial in criminal cases is mandatory. Under Section 1 of Rule 117, wherein pretrial in mandatory in criminal cases. In all cases cognizable by Sandigan Bayan, Regional Trial Court, Municipal Trial Court, the court shall, after arraignment, and within 30 days from the date the court acquires jurisdiction over the person of the accused, unless a shorter period or is provided for in special laws or circulars of the Supreme Court. For short, pretrial is mandatory in criminal cases and it shall be held after arraignment, after the court acquires jurisdiction over the person of the accused. After arraignment, take note that it is after arraignment and within 30 days from the court acquires jurisdiction over the person of the accused. But under the new rule on continuous trial, under Administrative Memo number 15-06-10-SC Revised Guidelines for Continuous Trial of Criminal Cases, once the court acquired jurisdiction over the person of the accused, the arraignment and pretrial shall be set within 10 calendar days from the date of the court receipts of the case for a detained accused, and within 30 calendar days from the date the court acquires jurisdiction over the person by arrest or voluntary surrender over a non-detained accused, unless a shorter period is provided by special law or Supreme Court. For short, if the accused is already detained, the arraignment shall be held and pretrial shall be held within 10 calendar days from the date of the court's receipt of the case for the detained accused. If the accused is not yet detained, the arraignment should be held within 30 calendar days from the date the court acquires jurisdiction over the person by arrest or by voluntary surrender. Take note that arraignment and pretrial shall be conducted on the same day. What if the counsel and the prosecutor did not appear during pretrial conference? So under Section 3, Rule 118, the court may impose proper sanctions or penalties if these counsels and prosecutors cannot give a proper or cannot offer an acceptable excuse for his or her lack of cooperation. What are the matters to be discussed during pretrial? First, the plea bargaining. Second is the stipulation of facts. The third one is the marking for identification of evidence of the parties. Next is the waiver of objections to admissibility of evidence. Fifth is the modification of the order of trial of the accused, admits the charge but interposes a lawful defense, and such matters as will promote a fair and expeditious trial of the criminal and civil aspect of the case. Pretrial agreements under Section 2 of Rule 118. All agreements or admissions made or entered during the pretrial conference shall be reduced in writing and signed by the accused and counsel. Otherwise, they cannot be used against the accused. So, take note that pretrial agreements should be in writing and it should be signed by the accused and counsel. If one of the requisite is absent, it will not be used against the accused. Thus, in People v. Uy, the Supreme Court ruled that even granting for the sake of argument that the accused admitted during the pretrial the exhibits against him and said admissions cannot be used in evidence against him because the joint order was not signed by the parties. To bind the accused, the pretrial order must be signed not only by the accused, but also by his counsel. So in this case, even though the accused admitted during the pretrial, the exhibits filed against him, presented against him, but such admission cannot be used as against him in court because the joint order was not signed by his counsel. Only the accused himself signed the joint order or the pretrial agreement. Pretrial order under Section 4, Rule 118. After the pretrial conference, the court shall issue an order reciting the actions taken, the facts stipulated, and evidence marked. Such order shall bind the parties, limit the trial to matters not disposed of, and control the course of the action during the trial, unless modified by the court to prevent manifest of injustice. The pretrial order limits the trial only to matters disposed of during the pretrial conference. Other than those matters were not discussed during the pretrial conference shall not be included during the trial unless there is a manifestation of when justice requires it. Rule 119, Trial. After a plea of not guilty is entered, the accused shall have at least 15 days to prepare for trial. That is under Section 1 of Rule 119. So again, the defense counsel, together with the accused, has only 15 days to prepare for trial. Under the new rule on continuous trial, the trial shall be set not later than 30 days from the termination of pretrial conference. So it means to say, from the date of pretrial conference has terminated, it will start the counting of 30 days, and it shall be set within 30 days. It will not lapse after 30 days, otherwise there would be a defect. So on regular cases, after arraignment, there will be a mandatory pretrial. After the termination of pretrial conference, the 30 days will count, and within that 30 days, the trial shall commence. And such trial shall only last for 180 days of presentation, of prosecution and defense of their exhibits. Again, after the termination of pretrial conference, within 30 days, the trial shall commence, and such trial shall only last within 180 days. And from the expiration of 180 days trial, judgment shall be promulgated, or the court shall make decision within 90 days from the termination of trial. While in drugs cases, still after the termination of mandatory pretrial, 30 calendar days to set the trial, and trial shall only last for 60 days from filing of information. So it's only very short period for a trial to last when it comes in drugs cases. And at the termination of trial, judgment shall enter. Promulgation of judgment is within 15 days from time of submission of decision. So again, in drugs cases, still 30 days shall apply after the pretrial conference, and the trial shall commence. And the trial on drugs cases shall only last for 60 days from filing of information. At the expiration of 60 days trial, judgment shall be promulgated only within 15 days from the submission of for decision. For environmental cases, after the expiration of 30 days for pretrial conference, the trial shall commence and it shall only be held for 90 days or 3 months from filing of information. And from the expiration of such 3 months or 90 days, there will be a 30 days for memo, filing of individual memo. Then after the 30 days, judgment shall be promulgated within 60 days from the last filing of memo. In intellectual property rights cases, still after the termination of pre-trial, within 30 calendar days or within 30 days, the trial shall be held, and the trial shall only last for 120 days or 4 months from filing of information, and each party has 60 days for their presentation. That is only for intellectual property rights, that the trial shall only be held for 120 days or 4 months, and each party shall be given 60 days for their presentation. And at the expiration of 120 days, there will be a 30 days for filing of their individual memos. Then at the expiration of 30 days, judgment shall be promulgated within 90 days from the submission of papers for decision. So again, after the expiration of 30 days, filing of their memo, 90 days shall start from the submission of papers for the promulgation of decision. When it comes with cases referred to mediation, the mediation period shall only last for 30 days. And after the 30 days of mediation, the trial shall commence, and such trial shall only last for 180 days. Again, after 30 days of mediation, there will be a trial, and such trial shall only last for 180 days. And after that, judgment is 90 days from the submission for decision. So again, after the expiration of 180 days trial, judgment shall be made within 90 days from the submission of papers for resolution. Order of trial under Section 11, Rule 119. First, the prosecution presents evidence. Prosecution shall present evidence to prove the charge, and in the proper case, the civil liability. So the very first is that the prosecution will present evidence to prove liability. And the next will be the defense. The defense presents evidence. The accused may present evidence to prove his defense and damages, if any, arising from the issuance of a provisional remedy in the case. So after the prosecution presenting its evidence, the defense will present its evidence. It's the accused's time to prove his defense. The rebuttal and surrebuttal. The prosecution and the defense may, in that order, present rebuttal and surrebuttal evidence unless the court, in furtherance of justice, permits them to present additional evidence bearing upon the main issue. So, in support of their presentation of evidence, they are allowed to rebut the other party, the presentation of evidence. Admissions of evidence and submitted for decision. Upon admission of the evidence of the parties, the case shall be deemed submitted for decision unless the court directs them to argue orally or to submit written memoranda. When the accused admits the act or omission charged in the complaint or information but interposes a lawful defense, the order of trial may be modified. So this is now the reverse trial, wherein if the accused admits the crime but interposes lawful defenses such as self-defense, that's the time it is the defense will present evidence, then followed by the prosecutor to present evidence. So generally it is the prosecution who will present first its evidence to prove the guilt, to prove the case filed against the accused. But if there is admission on the part of the accused and interpose a self-defense, then that's the time there will be a reverse trial, wherein it's the defense or the accused will present evidence first. When it comes to material witness, their testimony is very important and it will really help to prove the case. But what if the material witness will not testify? When the court is satisfied upon proof or oath that a material witness will not testify when required, it may, upon motion of either party, order the witness to post bail in such sum as may be deemed proper. Upon refusal to post bail, the court shall commit him to prison until he complies or is legally discharged after his testimony has been taken. So, under Section 11, Rule 119, during trial, the material witness is required to testify. But when the court, based upon proof or oath that the material witness will not testify when he is required, that's the time either of the party, either the prosecution or the defense, may file a motion to require the witness to post bail. Upon granting of the motion, but there is refusal of the witness to post bail, the court shall prison such material witness until he complies or is legally discharged after his testimony has been taken. When it comes to a state witness, if you are a state witness, you are discharged with your criminal liability, because being a state witness, it is tantamount to acquittal or equivalent to acquittal. That is under Section 18, Rule 119. There are two ways to become a state witness under Ampatuan Jr. versus De Lima. First is by discharge from criminal case pursuant to Section 17 of Rule 119. We will discuss this Section 17. The next one is the by approval of his application for admission into the Witness Protection Program of the DOJ in accordance with RA 6981, Witness Protection, Security, and Benefit Act. So, in connection with this, Section 17, Rule 119, these are the requisites to become a state witness. There must be two or more accused who are jointly charged with the commission of an offense. Again, there must be two or more accused who are jointly charged with the commission of an offense. The next one is the motion for discharge is filed by the prosecutor before it rests its case. So, the motion is being filed by the prosecutor. Then, the prosecution is required to present evidence and the sworn statement of each proposed state witness at a hearing in support of the discharge. Testimony of proposed state witness must be attached by the prosecution as an evidence. and the accused give consent to be a state witness. So these are the 4 requisites to become a state witness. So again, prosecution shall file a motion. How many period in filing the motion? The motion shall be filed before the prosecution rests its case. And the court shall require the prosecution to present evidence and sworn statement of each proposed state witness. So, again, the prosecution shall present the sworn statement of each proposed state witness as an evidence, because the court shall conduct a hearing in support of the discharge. Conditional examination of witnesses. There can be 2. For defense witness and prosecution witness. For defense witness, it is under Section 12, Rule 119, while for prosecution witness, it is under Section 15 of Rule 119. For defense witness, application for examination of witness for accused before trial. When the accused has been held to answer for an offense, he may, upon motion with notice to the other parties, have witnesses conditionally examined in his behalf. The motion shall state the name and address of the witness, the substance of his testimony, and that the witness is sick or infirm as to afford reasonable ground for believing that he will not be able to attend the trial, or resides more than 100 kilometers from the place of trial and has no means to attend the same, or that the other similar circumstances exist that would make him unavailable or prevent him from attending the trial. The motion shall be supported by an affidavit of the accused and such other evidence as the court may require. So the ground for the defense witness should be sick or other reasonable ground not to attend, and 100 kilometers away from place of trial. So if those grounds are asserted in the motion, then conditional examination of witnesses should be granted. How is that made? Under Section 13 of Rule 119, the conditional examination of witnesses shall be taken before a judge. It should be in the place where witness is residing, or if not practicable, a member of the bar in good standing so designated by the judge in the order, or if the order be made by a court of superior jurisdiction before an inferior court to be designated therein. So the examination shall proceed notwithstanding the absence of the prosecutor, provided he was duly notified of the hearing and a written record of the testimony has been taken. A copy of the order be served on the prosecutor at least 3 days before the scheduled examination. The testimony shall be recorded, and the deposition for defense witness must be done before trial. According to People v. Webb, it can be gleaned from the definition of deposition, and in keeping with the mode of discovery, it should be taken before and not during the trial. This time, let's go to conditional examination of witnesses for prosecution. This is under Section 15, Rule 119. When it satisfactorily appears that a witness for the prosecution is too sick or infirm to appear at the trial as directed by the order of the court, or has to leave the Philippines with no definite date of returning, he may forthwith be conditionally examined before the court where the case is pending. Such examination in the presence of the accused or in his absence after reasonable notice to attend the examination has been served on him. shall be conducted in the same manner as an examination at the trial. Failure or refusal of the accused to attend the examination after notice shall be considered a waiver. The statement taken may be admitted in behalf of or against the accused. So, what are the grounds when it comes for prosecution witness? It should be too sick or infirm to appear at the trial as directed by the order of the court, or he has to leave the Philippines with no definite date of returning. How is that made? How is conditional examination of witness for prosecution is made? The conditional examination of the prosecution witnesses can only be done before the court where the case is pending. This is Biudadem Guerra versus Rizos. However, in People versus Sergio, this is the case of Sarah Jane Veloso, wherein as a general rule, the witness should be present in trial or hearing for examination in open court under oath or affirmation. But Sarah Jane was detained in an Indonesian jail by reason that said witness cannot come to court under extraordinary circumstances. So therefore, since she cannot come to Philippine court because she is detained in an Indonesian jail, so her deposition was obtained. So, under criminal procedure like Section 12, Section 13, and 15 of Rule 119, because it is equivalent of depositions in civil case. In civil case, it is the Rule 23, but do not apply Rule 23 for criminal cases. Apply Section 12, Section 13, and Section 15, Rule 119 when it comes to witnesses or witness that cannot come into the Philippine court to testify because of extraordinary circumstances, like Sarah Jane Veloso is detained in an Indonesian jail, so only the deposition should be presented in the Philippine court. Question: will the Section 12, 15, and 13 of Rules 119 together with Rule 23 of the Civil Procedure, the deposition, taking of the position while pending action, will these rules violate the right of the accused to meet the witnesses face to face? The answer is no. Generally, the purpose of the right to confrontation is to afford the accused to an opportunity to test the testimony of the witness by cross-examination, and second is to allow the judge to observe the deportment or behavior of the witness. In Sarah Jane case, it was properly observed because the court gives guidelines in taking the deposition of Sarah Jane. In the case, the accused were not deprived of the right to cross-examination. They can still, or they are allowed to cross-examine through written interrogations or interrogatories. And as an accused, can cross-examine through written interrogatories. And the right to confrontation was also complied with, as the judge was present during the taking of the deposition through written interrogatories. Since we are talking about trial, speedy trial or speedy disposition must be invoked before any trial, because under continuous trial guidelines, if the period of arraignment was not observed, then as if it was not effective. The remedy of the aggrieved party here is to file an extension to extend the arraignment period, the entire proceeding of the trial. For ordinary cases, arraignment and pretrial shall be for only 30 days. The prosecution for trial shall be taken for 180 days. The rendition of judgment or promulgation of judgment from the presentation of the accused up to the termination shall be taken only for 90 days. So the entire criminal procedure shall only for less than 1 year. Take note that if the case is pending for 2 years or more, the accused invokes speedy trial under guidelines of speedy trial or speedy disposition. The remedy for the prosecution is use the principle of exclusion under Rule 119, Section 3. This valid claim for delay. So, under our Constitution, the speedy disposition of Article 3, Section 16 of the 1987 Constitution applies to administrative, quasi-judicial, and judiciary. Take note that the accused should be arraigned first before making him or her a state witness, because making such accused as a state witness is equivalent to a discharge or tantamount to acquittal. The essential requisites for the discharge of an accused as state witness is that the absolute necessity for his testimony, the material information that the state witness will really help the prosecution. Take note again that the accused to be discharged as a state witness must not be the most guilty. So it means to say he is not one of those the most guilty. Being a state witness is different from a witness protection program. State witness apply in court or filing of motion, while witness protection program apply to the secretary or to the Department of Justice. The accused who belongs to this witness protection program shall be excluded from the information, however, subject to the Section 14 of Rule 110. It states that the accused was included in the information, but the prosecution was convinced that they cannot prove the case against this accused, so in the meantime, he will be excluded. Again, take note, what needs to be proved before the court may discharge the accused as a state witness. Under Section 17 of Rule 119, there is absolute necessity for the testimony of the accused whose discharge is requested. So it should be an absolute necessity. It's indispensable and important necessity to help the prosecution. And there is no other direct evidence available for the proper prosecution of the offense committed except the testimony of the said accused. The testimony of said accused can be substantially corroborated in its material points. The said accused does not appear to be the most guilty, and the said accused has not at any time been convicted of any offense involving moral turpitude. The testimony of the state witness is absolutely needed, and there is no other direct evidence available for the prosecution of the offense committed. So it means to say there is no other direct evidence that will really help the prosecution in proving the crime except the testimony of such state witness. And the testimony is substantially corroborated in its material point. It means to say substantial, very important. It will really help. It is badly needed. And the accused is not one of those. One is not to be the most guilty. It means to say not totally guilty. Just an accessory. And also, the said accused to be a state witness is not convicted of a crime involving moral turpitude, such as fraud, estafa, perjury, falsification. So those are crimes involving moral turpitude, and in which whatever the accused may say, it is false, with mistake, and cannot be trusted, is not trustworthy. What if there is mistake in charging the proper offense? So mistake in the information. Under Section 19 of Rule 119, when mistake has been made in charging the proper offense, when it becomes manifest at any time before judgment that a mistake has been made in charging the proper offense, and the accused cannot be convicted of the offense charge or any other offense necessarily included therein, the accused shall not be discharged if there appears good cause to detain him. So, in such case, the court will commit the accused to answer for the proper offense and dismiss the original case upon filing of the proper information. So, if there is a mistake charging the proper offense, so if the accused committed robbery, but in the information it was alleged only committing of theft, and the court found out that the accused cannot be convicted of theft, so therefore the court will not discharge the accused if there appears a good cause to detain him. So it means to say there is a probability, there is an evidence pointing that he commits the intention of gaining illegally. The court shall commit or order the accused to answer for the proper offense and dismiss the original case and ask the another information alleging properly the offense of robbery. In addition, in relation to Section 14 of Rule 110, Paragraph 3, if it appears at any time before judgment that a mistake has been made in charging the proper offense, the court shall dismiss the original complaint or information. Upon filing of a new charging the proper offense in accordance with Section 19 of Rule 119, provided the accused shall not be placed in double jeopardy. The court may require the witnesses to give bail for their appearance at a trial. So again, it's just only the same, wherein if the information or complaint allege only for theft, but it was proved that there is robbery and the accused cannot be convicted on theft, so therefore the court will order the dismissal of the original complaint and ask for the filing of new complaint alleging the facts and circumstances of committing robbery. What is the difference between substitution and amendment? In Pacoy versus Kajigal 2007, if the second information or the new information involves the same offense or offense which necessarily includes or is necessarily included in the first information, so therefore amendment only shall be made. Amendment is made or is sufficient. But if the second information does not involve the same offense or offense which necessarily includes in the first information, then therefore it should be a substitution. Again, if the new information filed involves the same offense with the first information, then file or make an amendment. But if the new information does not involve the same offense charge, or it is distinct and different from the first information filed, therefore substitution is proper.